proceeded by consent of all parties, and the fifth accused effectively acquires his right to raise that issue. Now, regarding the case, Mr. Mutuku urged that at the time of the elevation to the Court of Appeal bench, this court had 42 prosecution witnesses, with 2 prosecution witnesses remaining to close of the case. It was his submission that this court's ascension to the Court of Appeal did not rob the court of the unlimited original jurisdiction to conclude the matter. Mr. Mutuku urged that this was not a new occurrence in Kenya's history in the administration of criminal justice. He drew court's attention to the 6th announcement of the Judges and Magistrates Vetting Board dated 15th of January 2013 by Sharad Rao, who was chairperson of the board, touching on the determination number 5 of the board. It is a post-2010 occurrence. Council gave example of 2 judges appointed to higher benches from the High Court in 2011 and 2012 who sought for and obtained leave from the Chief Justice to be off the course list of the higher courts in order to finalize their pending matters in the High Court. I have considered the submissions of learned counsel Mr. Michuki and also Mr. Mutuku on the issue of quorum non judice. The arguments of Mr. Michuki are that after this court heard the entire case, it ceased to have jurisdiction to write judgment on grounds it had since taken oath to serve in a higher bench. He quoted no legal provision to support that position. At the same time, he acknowledged that there was no law that spelled out which court had jurisdiction to hear murder cases, stating that indeed the jurisdiction of the High Court to hear such cases was out of practice and custom in exercise of its original jurisdiction. If I heard Mr. Michuki well, he was at a loss whether the law supports the trial of murder cases by the High Court. In other words, I did not have jurisdiction to hear the case in the first place. He is not alone in that dilemma. The issue of the jurisdiction of the High Court to hold murder trials was the subject of a case, that is Charles Henry Nyaoke versus Cabinet Secretary for Ministry of Interior and Coordination of National Government and 4 others. It was a High Court petition, Kisumu, in which I was the presiding judge. Now, in that case, the court observed, and I quote, "As regards criminal cases, the criminal procedure sets out further jurisdiction of the High Court in the exercise of its original jurisdiction in criminal cases under Part 2 titled Powers of Courts. It provides, subject to this court, an offense under the Penal Code may be tried by the High Court or a subordinate court, by which offense is shown in the 5th column of the first schedule to this court to be triable. An offense under any law other than the Penal Code shall, where the court is not mentioned in that behalf, in that law, be tried by that court. Now, where no court is mentioned, it may, subject to this court, be tried by the High Court or by a subordinate court by which the offense is shown in the 5th column of the first schedule to this court to be triable. Now, under the 5th column, the first schedule of the Criminal Procedure Code, the court which may try a person charged with murder under Section 203 of the Penal Code is not indicated. We have carefully evaluated the rival submissions made by the parties to this petition. In that regard, it was clear to us that the parties herein are asking the court to interpret Article 165(3)(c) of the Constitution to determine the delineation of the jurisdiction of the High Court in hearing and determining criminal matters in exercise of its original jurisdiction. In the present petition, it is apparent to this court that the assignment of jurisdiction to the High Court to hear murder and treason charges under the Penal Code under Section 4 and 5(2) of the Criminal Procedure Code may appear to be arbitrary if the history and the context is not taken into consideration. For the proper understanding why murder and treason are currently the only charges that are tried by the High Court in exercise of its original jurisdiction, it is important for the historical context to be set out. Now, other than the statutory requirements under the Criminal Procedure Code, the majority of which have been repealed, it is apparent that the trial of murder charges before the High Court is a historical accident, close quote. Now, the issue whether this court has jurisdiction to complete the trial and write a judgment calls for a holistic consideration of the values and principles of the Constitution, as well as the circumstances of the case and the parties and the public interest, if any. I do not ascribe to Mr. Michoke's submission that it appeared readily apparent that appointment to the office of the Judge of the Court of Appeal automatically repealed the previous appointment as a Judge of the High Court by necessary implication. To repeal means to revoke or to rescind. The definition of a repeal is the act of taking something back, to reverse, approbate, annul, invalidate, nullify, void, recant, retract, and all those. In order to repeal an appointment that had been gazetted, the same process would have had to be undertaken. It would have to be gazetted. It cannot stand revoked by necessary implication, as counsel has suggested or urged. The Constitution did not provide transitional provisions dictating or providing for what should happen to partly heard matters before court, where the presiding magistrate or judge is elevated to a higher bench. It did not prescribe either whether a judge elevated to a higher bench could finalize pending matters. The Constitution is dead silent on this issue. Does silence mean that the Constitution has ousted the jurisdiction of a judge elevated to higher bench to conclude its cases upon elevation? So the principle applicable interpretation of articles of Constitution set out, I've quoted a case by Judge Mwita. Now, I agree with Mr. Mutuku that directions given by the Honorable the Chief Justice to the judges appointed from the High Court to the Court of Appeal to complete their respective advance partly heard matters was an administrative action that was authored or anchored in the law, Section 16A, C, and E of the High Court Organization and Administration Act number 27 of 2015, and likewise Section 5 of the Judicial Service Act, which is also in tandem with the High Court Organization and Administration Act, High Court Organization and Administration Act. I do not want to appear to read the Honorable Chief Justice's mind when she gave the directions in issue. However, the lack of any express guiding provision in the Constitution on the issue must have been an integral reason for the action and direction given by Her Ladyship, the Honorable the Chief Justice, that the Constitution was silenced. Thus, the head of the judiciary exercised statutory powers in the two statutes quoted above to guide that process. There can be no vacuum. There can be no occasion for a vacuum that courts of law will fold their hands and say there is nothing they can do because the law is silent. This is why courts' intervention in judicial review under the doctrine of ex debito justitiae has the force of law. I believe that the issue of hearing and disposal of cases, which is the core function of courts in this country, is a matter affecting the dignity, the accessibility, effectiveness, expeditious disposal of matters, and functioning of courts. It also has a great bearing on the application by courts of constitutional values and principles. Every successive Chief Justice, especially since the promulgation of the Constitution 2010, has enhanced the operationalization of the values and principles of the Constitution, good governance, and the rule of law by framing visions. These visions, shared by way of transformation frameworks, guided the core function actors and all support system actors in the judiciary on the best practices that guarantee optimal, effectual, expeditious, and responsive functioning of the judiciary and that protect and guarantee access to justice to all, even before the promulgation of the current constitution, every Chief Justice, through practice, directions, rules, and policies, guided the processes of the judiciary in order to be effective and intentional in giving responsive and seamless services to all her clients and enhance administration of law. To that extent, and in that regard, the impugned direction of the Honorable Chief Justice Martha Koome were not unique, unusual, or novel. Now, I am for the promotion and preservation of equality and equity to all, the accused persons first and foremost, and the victims, the public interest and dignity of the entire trial process. It is important that courts stir public confidence in bearing and determining cases across the board that cannot be effected if courts can commence cases and then abandon them at will on grounds of technicalities or excuses on grounds of quorum non judice. In order to have a holistic perspective of the issue at hand, it is important to take into account several facts about this case. First, the accused persons were arraigned in court with these charges in 2016, July. Secondly, the matter began before another judge who had 2 witnesses before recusing herself due to the perceived length of the case that made it difficult to abandon her single judge station to attend to this matter. Thirdly, the court has taken 5 years to hear the case, hampered by many factors, and the most challenging being the COVID-19 pandemic that shut down courts for a considerable period. And fourthly, the court had a total of 46 witnesses for the prosecution, 7 witnesses in the trial within trial, and 19 defense witnesses. That makes a total of 72 witnesses. Fifthly, there were 11 lawyers in this case for the state, the defense, and the victims. Sixthly, there are over 6,700 handwritten notes of proceedings in 10 files in this matter, excluding documentary exhibits and submissions of counsel. Seventhly, this case had 3 witnesses under witness protection. Eighthly, the case involved a public interest issue of grave importance. Ninthly, one of the accused persons, that is the 5th accused, in this case is also under protection and was kept at Naivasha Maximum Prison when his co-accused were held at Kamiti Maximum Prison. And lastly, there were 117 exhibits for the prosecution and 34 exhibits for the defense. Not to mention that if there is an interruption in the conclusion of the matter and the case is given to another judge to handle, there are several implications. First of all, the cost factor to the public offers will be enormous, considering but not limited to state officers who will be engaged in handling the matter. Second, the other important question to consider is what will be the effect or impact of handing over this file to another judge in the criminal division. If they will have to proceed to write judgment, how long will it take the judge to understand the numerous volumes of proceedings before penning down a judgment? And third, what guarantee will there be that witnesses will be found, supposing the matter were to be ordered to be tried afresh 7 years down the line? And fourth, what trauma will the families and colleagues of the deceased continue to suffer due to the prolonged waiting for the final determination of the case? And fifth, what of the accused persons having to have the case start all over again? Even the most strong and patient of them all will have trauma by such a move. I believe that it will be against public interest and public policy, and it will not serve efficacious disposal of this case to adjourn it and hand it over for continuation by another judge. Such an action does not settle well with the need to uphold the purpose, value, and principles of the Constitution, especially those touching on the expeditious delivery of justice without unreasonable delay, including advancing the rule of law, human rights, and good governance in exercise of its judicial authority, as obligated under Article 259(2)(e) of the Constitution, constitutional values, principles, and the rule of law, and public interest will be best served by declining the invitation by counsel for the fifth accused to declare this court quorum non judice. Now, the other issue was the identification of the bodies of the deceased persons and the post-mortem examination. The bodies of the deceased persons were identified to the pathologist, who was Dr. Odor Johansen, PW 19. Now, PW 19, the head of forensic medicine and chief government pathologist in the country, stated that on the 1st of July 2016, late in the afternoon, he was informed that there were bodies at City Mortuary that required post-mortem examination. He decided that there was need for X-ray and CT scans to be conducted on the bodies, since there was need to establish whether there were any fractures in the bodies which might be missed out during post-mortem. He asked for the bodies to undergo CT scans at Kenyatta National Hospital, and the same was conducted by Dr. P. Otieno, and the scans the report was part of what was exhibited. Now, PW19 stated that he conducted the post-mortem on the body of Willie Kimani on 4th of July 2016. He stated that he received the CT scan of the subject. The scan indicated that the subject had a fracture on the skull on the left side extending to the front side of the skull into the left eye socket bone. He also had a fracture on the right upper jaw and on the left cheekbone. He also had multiple skull and facial bone fractures. On post-mortem, PW19 stated that externally, the subject body had features of decomposition, including skin slipping. He stated that the body was distorted, swollen, and was darkening on the lower limbs. Blood was oozing from the mouth and the nose. He further stated that it had a laceration on the right side of the head, which was 2 centimeters long, and abrasions on the forehead. The left side of the head was deformed, and there was a contusion bruise on the back of the left head. He noted a deformation on the right side frontal parietal region of the head, which he explained as being a bash inside the head, indicative of a fracture underlying it. He indicated that there was a contusion on the back of the head, which was about 120 centimeters from the middle of the head, an abrasion of the right side of the head, an abrasion above the left eye, and an abrasion near the ear. He finally stated that there was an extensive bruise on the anterior wall. PW19 stated that internally the body of the deceased had signs of bleeding on the muscles of the chest, which were more on the right side. He stated that the lungs, the heart, the pancreas, the liver, and intestines, and the spleen were decomposing. The abdomen had bruises on the internal right side. The stomach was empty, and the bruises were noted on the testicles. Now, he further stated that the head had hematoma of the skull, fractures of the left skull extending to the front, on the left eyeball and bone surrounding it, that on the right maxilla, upper jaw, and on the cheekbone there was a fracture. He stated that the subject's brain had liquefied because of decomposition and mixing with the blood. He concluded that the cause of death of the first deceased was due to head injury due to blunt force trauma. He described the bruising on the left forearm and the left elbow. They can sit.
Sorry.
Is that the reason of the sound?
I think the microphone.
Okay, he described the bruising on the left forearm and left elbow as defensive injuries, and produced the CT scan in respect of the first deceased as Exhibit 29. His post-mortem form as Exhibit 29. The CT scan was Exhibit 29A, and the post-mortem addendum is Exhibit 29B. PW 19 explained that abrasions and scars could have been caused by a blunt object, or the contusions on the right temporal and cervicular region were caused by a blunt force trauma which caused bleeding under the skin. He stated that the defensive injuries were the ones he saw on the left forearm, and further explained that the injury to the head was very severe because of the extent of the fracture. He stated that it could have been caused by a drop of a stone or object on the head, or a drop from a height. He stated that in his opinion, the immediate cause of death was the head injury due to its severity. He stated, PW19 stated that he conducted post-mortem of the third deceased on the 4th of July 2016, and that his CT scan revealed no fractures, no bullet holes, and no cartridges, and his cartridges were normal. He stated that externally, the third deceased body revealed features of decomposition, including skin spillage, swelling and darkening of the skin. He stated that there was blood oozing from his nose and mouth. He further noted a bruise on the left cheek below the ear and a complete ligature mark and bruise around the neck. He stated that internally the third deceased body had a bruising on the surface of the thyroid bone cartilage. The hyoid bone was loose but not fractured, and there was bleeding on the chest. He stated that the lungs, the heart, the intestines, the liver, the kidneys, and the spleen were all decomposing. He further stated that there was a bruising on the scalp on the left and the back side. He stated that the brain was deluxified owing to its decomposition and mixing with blood. He further noted a bruise on the spine at the neck region area, hematoma, bruising of the left forearm from the wrist and on the left leg above the ankle and above the left knee. PW19 indicated that his conclusion was that the cause of death of the third deceased was ligature strangulation. He explained that the head injury was inflicted before the rope was tied to the neck. Therefore, the immediate cause of death was the ligature strangulation. He produced the postmortem report, the CT scan, and the postmortem addendum, Exhibit 30, 30A, and 30B. Now, PW19 said that he conducted the postmortem on the second deceased, on the body of the second deceased on the same day as the other two. He stated that the CT scan in respect of the second deceased revealed no fractures on the skeleton and no evidence of bullet entry was seen. PW19 stated that externally the body was decomposing and it had a bruise on the left eye, swelling above the left ear. He also noted an old scar on the inner aspect of the forearm and wrinkling of the foot, which he explained as being a sign of someone being removed from water. PW19 stated that internally the second deceased had hematoma on the thyroid cartilage, bruises on the left chest muscles with internal bleeding. He stated that the lungs, heart, pancreas, liver, kidneys, and the spleen were all decomposing. He noted the bruises on the neck, the left ankle, and left leg below the knee. He made the conclusion that the cause of death of the second deceased was injuries to the head, the neck, and the chest. He explained that the hematoma on the thyroid cartilage was indicative of pressure applied to the neck. He further stated that the injury on the forearm was a healing scar. He produced a post-mortem in respect of the second deceased as Exhibit 31, CT scan 31A, and the addendum to the post-mortem 31B. PW19 stated that he visited the scene where it was alleged the trio were murdered with an aim of looking for any biological exhibits, but he did not collect anything. He stated that all the injuries on the deceased persons' bodies were inflicted when they were alive, because one only bleeds when they are alive. In answer to a question put to him, PW19 testified that with the level of decomposition, it was difficult to see the ligature marks on the bodies. The issue of the cause of death or causation of death raised by Mr. Michoke is a challenge inter alia as to whether the fifth accused really knew how the deceased persons were murdered, as it is clear he did not himself either stand by to watch the deceased being murdered or participate in terms of strangling, hitings, assault, or in any such cause, or in any such way cause injury to them. The fact is, by the time they ferried the deceased to River Athi, they were dead as a result of assault executed against them that night. In any event, in addition, the evidence of Dr. Johnson that due to composition, injuries may not have been easy to note. It is clear the deceased were battered by their tormentors. They've already said the injuries which they had. So I say that I find no material variation between the confession by the fifth accused and the findings of the pathologist. Now, I must mention that the way to challenge the evidence of an expert, which includes a pathologist, is settled in law. Now, in cases including those that were cited by counsel, there is the Republic versus Landfair, a 1968 All England report, which says that our view is that the evidence of a doctor, whether he be a police surgeon or anyone else, should be accepted unless the doctor himself shows that it ought not to be, as the evidence of a professional man giving independent expert evidence with the sole desire of assisting the court, and the famous one of Dali versus Republic, that it is now tried law that while the courts must give proper respect to the opinion of experts, such an experts are not, as it were, binding on the courts, and the courts must accept them. Such evidence must be considered along with other evidence available, and if there is a proper and cogent basis for rejecting the expert opinion, a court would be perfectly entitled to do so. There was no challenge to the findings of the pathologists on the postmortem examination of the deceased bodies. No question was put to Dr. Odor to explain his findings or expound on the basis of his findings. I appreciate that Mr. Michoke was not present when the pathologist testified. However, he had the right to recall him for further cross-examination when he came into the case, as he exercised in respect of the government chemist, Dr. Kimani. Now, having taken into consideration the findings by the pathologist and the circumstances under which the bodies were found, which I don't want to repeat, I find that the expert opinion of the pathologist was proper and cogent, and that there is no grounds not to accept his evidence. I'm satisfied that the prosecution case as to the cause of death was clear and confirms that the deceased persons were murdered. Now, whether the DNA analysis report by the government chemist, which I don't want to repeat, should be rejected for non-compliance with sections 122A, B, C, and D of the Penal Code. Now, Dr. Kimani was PW2, the government analyst. He told the court that on the 30th, they received exhibits and swaps, that is on 3 occasions, 13th of July, 15th of July of 2016, and 29th of August 2016. Now, Mr. Michoke submitted that the right of the accused person was violated because the samples taken from him were illegally acquired evidence contrary to Article 50, sub-article 4 of the Constitution. He challenged the admission of Exhibit 72, the government chemist report, which included the results of analysis of samples